Okay, Wayfair, what is it? And I'm going to give you the punchline here. So Wayfair, of course, is the company, the online seller of home furnishings, wayfair.com. There was also a court case, though, and that's really what I want to talk about today. This was the Supreme Court case that came out in June of 2018. And basically, what this did, it really enabled the states to impose their sales and use tax on remote sellers that are selling their goods into a state. In this case, it was South Dakota. And this is really big. This was the biggest thing I would think in 50, 60 years of state local taxation. Before, you had to have a physical presence in a state in order for a state to be able to require you to collect sales tax. After Wayfair, that has gone away, and that has really turned things on its head and really been a big change. So with that as the background, let's talk about how we got to Wayfair. I'm not going to spend a whole lot of time on this, but I do think it's helpful to you can't understand, what's the old saying, you can't understand where you're going if you don't know where you've been. And so this is an overview of Nexus milestones. And I think what's interesting about this has cases, various things that happened in the concept of state local taxation. And it starts in 1940 with this J.C. Penney case. And I think if you see there's a development every 10, 15 years. It's pretty slow development up until about 2015. And then in 2015, things really take off, and we'll talk about that here in a second. Let's talk about this first case. This is the National Ballast Hess case, 1967. Illinois wanted to require a remote seller to collect tax on sales that were made to Illinois residents. And how were those sales made? Well, they were made via catalog. Illinois attempted this. It went up to the Supreme Court, and the decision that came out of the Supreme Court was no, that's not good enough to allow Illinois to require collection of tax. And what comes out of this case is the concept of having to have a physical presence in the state. There were two, the due process clause and the commerce clause. I'll talk about those a little bit more. But under both of those provisions, the court held that now a physical presence must be required. And so that's kind of where the physical presence concept emanates from. So what is physical presence? Well, it can be direct or it can be indirect. On this slide, obviously, if you have an office or a facility in a state, that's going to create a physical presence for you. A sales force, if you have people going into the state to solicit sales, that's a physical presence. It can be a physical presence that's post sale activities. If it's repair, installation, delivery, those type things, that's going to create a physical presence for you. And it can also be indirect, and that can be a little bit tricky. That's really almost an agency type concept. You have someone acting on your behalf within the state. That was the Scripto case that I mentioned earlier. That was, where is that? 1960. That was one of the earliest instances where we had a court say that, yes, having an agent in the state, that is physical presence. So it's really anyone doing something on your behalf to enable you to make a sale. And we'll talk about that later. That can be tricky to identify. And there was a lot of court cases, audits, what is physical presence? So kind of moving on. Complete auto transit. That's the next case. Really, I'm not going to linger on that one. The point to be made there is this concept of substantial nexus in bold. You really hear the courts, taxing authorities talk about what is a substantial nexus. I mean, a substantial nexus is that level of activity that allows a state to tax you. And as we've learned for sales and use taxes, that substantial nexus did require a physical presence. But you see this case mentioned a lot. It's in every tax case that has come after it. It's always measured by these requirements. So moving on, let's talk about Quill versus North Dakota. I think that's the next big thing that happened. So, Quill versus North Dakota, that's 1992. So if you think about, what has really changed from 1967 to 1992 as far as how people buy goods, not in person, and it's probably not a lot. Again, Quill is another catalog case. And in this case, it's North Dakota who is trying to tax an out-of-state retailer. Again, this goes up to the Supreme Court, and it's kind of a split decision here. Overall, it's a win for taxpayers, but what the Supreme Court does, they revisit Ballast Hess and they overturn the part that says due process has not been met. They I guess better said, they say that due process, it is okay under the due process clause for a state to try to tax an out-of-state retailer without a physical presence. That's kind of based on notions of fairness. The thought is that, look, if I'm a company and I'm trying to get sales from residents of North Dakota, then it's probably fair for the state to try to tax me and collect the tax. However, what the court also said is under the Commerce Clause, that is not sufficient. They kind of hold their ground on the Commerce Clause and say that a physical presence is still required even in 1992. And again, from that perspective, maybe things haven't really changed much in the 25 years from Ballast Hess. But what the court says here in Quill is that, right or wrong, Ballast Hess established what the rule is. And for clarity and predictability, we're not going to change that. So the continuing value of a bright line rule in this area and the doctrine and principles of stare decisis indicate that the Ballast Hess rule remain good law. So, maybe reading between the lines, if the court had to take it fresh from 1992, maybe they'd come up with a different approach. Maybe it wouldn't be physical presence, but people have come to rely on it, and that's still the law. So 1992, and you think about, okay, well, what happens after 1992? And think about your own experience if you were in school or in the workforce then. I mean, in 1992, did you have a computer? Did you have a laptop? Probably not. I graduated law school in 1992, and I think maybe 3-4 people in my class had a laptop, and it was novel, and it was, wow, look at a computer that looks like a book, kind of crazy. And if I wanted to use a computer, well, I had to walk over to the law school and use the computer lab. And I think that probably mirrors a lot of people's experience. And even when I got to the Attorney General's office in the mid 90s, I was thinking back about that, and I was there from 1996 to 98, and we had computers, desktop computers, and we could email one another, but we didn't have internet access. And I remember if you wanted to get on the internet, there was one computer that was hooked up to the internet. You had to go log in, and it was really kind of a big deal to be on the internet to do your research. And that sounds ludicrous today, but that's just how things were in the mid 90s. So with Quill as the jumping off point, let's think about kind of how things developed after that. And, in the 1990s and the 2000s, the states are struggling to collect or to live with Quill and the physical presence requirement, but still collect tax on these sales that are occurring. And it was also interesting as I was preparing for this, thinking about, we know where we are now as far as e-commerce and internet sales, but it's kind of funny to look back and think about some of the common names that we know now when they came about. Amazon was founded in 1994, eBay 1995, PayPal and Google were in 1998. And you think about that, you really see the advent of online internet sales. And, you think about when that was first available, you could, I could go down to the local store and buy something. I guess I could order it online. If I do that, maybe I don't have to pay sales tax because that online retailer doesn't have a physical presence in Tennessee. But if I do that, okay, gosh, I'm probably gonna have to pay a lot for shipping and handling, certainly more so than what the tax would have been. If I get it and I don't like it, how am I gonna get it returned? And if I get it at all, it may be a week or two before it gets here. So, okay, what's the remedy to that? And that's, you see Amazon Prime comes about in 2005, which really, kind of negates a lot of those concerns. Venmo in 2009. So again, you see how the economy is developing, changing throughout this time. And then you think about the states being saddled, if you will, with this Quill physical presence requirement. How do they get around that? How do they try to collect tax and live within Quill? So a lot of things happened during that time. And this is on the slide. You have the Streamlined Sales and Use Tax Project. That was where a lot of the states got together and tried to simplify the process of collecting sales tax. I think there's 22, 23 members now of the Streamlined Sales and Use Tax Project. Tennessee is an associate member. I think we're the only associate member in that. And that had high hopes for facilitating collection of sales tax by internet sellers. It still exists. It's still there. We'll talk about that a little bit when we get to the Wayfair decision. But then the other things that are going on, there's bills introduced in Congress almost every year. I've mentioned the Marketplace Fairness Act, and there was, all these bills that have different acronyms and different names. Some did purport to get rid of this physical presence concept. That's the Commerce Clause. The ability to regulate commerce between the states is reserved to Congress. And so the Supreme Court came up with physical presence because Congress had not stepped in. But Congress always had the purview to come in and set up some other requirement, something more than physical presence or something less. And so you'd see these bills every year get filed and talked about, but nothing ever happened in the Congress with respect to these bills. The other thing I mentioned earlier, this concept of indirect presence, agency nexus. And you saw a lot of that. We really saw a lot of that here in Tennessee. And, that is always a factual inquiry. Sometimes the facts are clear, sometimes they're not. And I think the states, some were more aggressive than others in trying to find an agency relationship. Oh, you have somebody in the state doing something on your behalf, again, to drive a sale. Therefore, you have a physical presence. It's not you directly, remote seller, but you have an agent in the state that's creating Nexus for you. Again, very factually difficult to sort out sometimes. The other thing we saw a lot of is the notice requirement, and that's something we're going to talk about in the Broll case. The notice requirement kind of acknowledges that, okay, we have to have a physical presence before we can be required to collect tax. But what this did, and Colorado is one that went down this path, is that, okay, remote seller, we realize we can't require you to collect the tax, but what we are going to do is require you to send us a list of all the customers in Colorado who have ordered your goods, and then we're going to send those folks a notice that, hey, we understand you've purchased something on the internet. We think you may owe use tax. And Tennessee used to do that. You would get a use tax return. That didn't happen every year, but I recall a couple of years I received my use tax. So if I had bought something out of state and didn't pay sales tax, that was reminding me that I had the obligation to pay use tax on that. The other one was click-through presence. That was really a physical presence concept, but basically that was saying if you are a remote seller and you're selling through an online platform that does have Nexus, say in New York, okay, that customer clicks on that link and it goes to your website where they can buy your widget. Well, that is a physical presence because the facilitator for that is in New York. Therefore, that creates physical presence for you. Some people, were proponents of that. Some people thought that was tortured logic. And then maybe the last one I'll talk about, and this is kind of my favorite, this is called Cookie Nexus. And a lot of you may know when you go to a website, that website, it may ask you that, hey, are you okay if we place cookies on your computer so that if you come here again, you'll have a smoother experience. And so those cookies, that's software, that's in my mind, intangible property, but a lot of states, and I'm picking on Massachusetts, but I think they were one of the first, their point of view was that, well, okay, remote seller, if you're placing cookies on a Massachusetts resident computer, you have a physical presence in Massachusetts via those cookies. So again, maybe tortured, maybe makes perfect sense. I think it depends on what side of the where you are on the spectrum. Again, just kind of shows you just the really all the things that were going on to try to adhere to Quill, but requires or allow states to collect the tax. And so I mentioned earlier that things are kind of slow developing until we get to 2015, and that's this Direct Marketing Association versus Broll, and this was one of the Colorado notice requirement. And that case is not notable for its holding. The court did hold that notice requirement was okay. It was all right for Colorado to require remote sellers to send in a list of their customers. But what really came out of that was a concurring opinion by Justice Kennedy. And that's at the bottom of the page here. And he agrees with the Broll holding, but he kind of goes out of his way to point out about Quill that essentially saying that, Quill is erroneous and outmoded and really looking for an opportunity, a case, bring us a case where we can revisit Quill, and we'll revisit this again. And maybe that's appropriate. You know, you had Ballast Hess in 67, Quill in 92, and 25 years, and here we are 25 years later in this Broll case. So the states were listening to that. And so that kind of initiates the race to kill Quill, if you will. So the states hear Justice Kennedy, you know, they're kind of fed up. They're kind of tired with all these mental gymnastics they're having to go through. So the states jump into action, and Alabama is one of the first. They promulgate a rule that says, hey, if you're a remote seller and you're selling over 250,000 of sales into Alabama to our citizens, you must register and you must collect tax on those sales. Now that's clearly runs afoul of Quill, but the states didn't care. They were looking for a way to get back into court. Tennessee was actually an early actor on this. We had an agency rule in 2016. We chose 500,000 as a state. If you meet 500,000 during the prior 12 months, then you need to register and collect tax. Again, blatantly goes against Quill, but the states didn't care. South Dakota actually passed a Senate bill. The way that law was enacted, it really allowed them to get to court first. But just know by April of 2017, 2 years after the Broll case, you have 20 states that have enacted some form of anti-Quill statute or regulation. So then that leads to the big question. Justice Kennedy invited someone to bring a case. So which state's going to get to the Supreme Court first? And I guess more importantly, what is the Supreme Court going to do? It's fine for Justice Kennedy to invite, the court to hear it again, but that doesn't mean that, they're going to overturn Quill. And so what's going to happen next? That's the big punchline. And before I get to the punchline, there were a lot of us who in this industry who thought, well, yeah, maybe physical presence is not a great answer, but it's been around for 50 years. We don't think the Supreme Court is going to overturn that. They haven't yet. They've kind of left it to Congress to step in. And so a lot of folks, including myself, thought, well, yeah, the court's going to just uphold Quill. The flip side of that would be too chaotic. I mean, can you imagine what would happen if Quill's gone and every state gets to impose their own economic nexus provision? It could be 100,000, 500,000, 250,000. Can you imagine the chaos that would ensue were that to happen? And so then we get to the South Dakota versus Wayfair case. And South Dakota had their threshold. It was $100,000 of sales or 200 or more separate transactions. If you hit either one of those, you were required to register and collect tax. The Supreme Court took it. They reviewed it. No surprise, Hancock turns out to be wrong. The Supreme Court does overturn Quill. And it's kind of interesting. It was a 5-4 decision to get rid of Quill and physical presence. And it's interesting, had you just had one justice go the other way and hold the line, here today in 2020, we'd be talking about physical presence and how the states are trying to get around that. But that didn't happen. Quill is gone as of that day, and chaos has been unleashed. Now, what the court looked for was really three things. They said, okay, the South Dakota law seems to be okay. There's a safe harbor. If you're below 100,000 or below the 200 transactions, then you don't have to collect tax. That's kind of a safe harbor, maybe for the smaller operators, the mom and pop shops. That was one of the things that was important to them. The other thing is that this bill or this law did not purport to go back retroactively. And tax years, that were long past, long since gone. I think that happened in Quill. That was part of the concern there that, states would try to go back retroactively. Wayfair, that did not happen. It was going to be prospective only. And the third thing was just ease of compliance. And part of that was the fact that South Dakota was in the streamlined sales and use tax program. They didn't say that was a requirement, but the court certainly indicated that there needs to be some mechanism to allow remote sellers to more easily collect and remit this tax. That's really the punchline there. Some other things that are interesting about South Dakota versus Wayfair, as I noted, it was a 5-4 decision, the thinnest margin it could have been. Justice Kennedy got what he wanted. He was one of those 5 that voted to get rid of Quill, and then he promptly retired after that. So mission accomplished, I guess, for Justice Kennedy. It's interesting, the 4 justices that were on the other side that voted to uphold Quill, they didn't do it because they thought that physical presence was the right answer. In fact, all 9 of the justices held that, this physical presence, it's outmoded. It doesn't work anymore. It's just that 4 of those justices were willing to kind of hold the line on the basis of stare decisis. And that's kind of it is a legal concept that, if you have prior decisions of the court, unless the facts really warrant a change, we're not going to change that. And so 4 of those justices were relying on stare decisis. And it makes you wonder, what other precedents might they have been thinking about, that they want to hold the line on the grounds of stare decisis. And so they kind of put a stake in the ground with Wayfair. But again, it's interesting that all 9 said physical presence was not the right rule. Some of them even said it was a bad idea in 1967. And that, I was really struck by that. And that's my point in the last bullet there. Okay, so we've just been doing this all wrong for 51 years and just nobody knew it. But regardless, that is what it is. So that's the Wayfair case. So now this gets to, all right, 2 years past Wayfair, what's the takeaway from this? And as I see it is, before Wayfair, you had control over where you establish Nexus for sales and use tax collection. With Wayfair, you really don't. You have to look at where your customers are located. And, where are your customers located? If you're selling tangible personal property and you know where goods are being shipped, okay, maybe you know where that sale is, you know where your goods are going, you know how to assess these thresholds in the state. But what about the sale or lease of software? That gets trickier. A lot of states will tax software. They either include it in the definition of tangible personal property, they impose it directly on software. They may say it's a type of service. Texas does that. So what about a sale or lease of software? Do you know where your customer is in that case? And what about where you're selling software, licensing software that could be accessed by users all over the country, users all over the world? How do you take that into account for these Wayfair purposes? A lot of states, Tennessee included, have allowed almost an allocation. You look to how many users are in Tennessee, you apply that over the number of users everywhere. 10% of those users are in Tennessee, then you would remit tax on the 10% of that purchase price. Not every state is doing that. I think it's a good idea. It's I think you have to give remote sellers some hope of trying to be able to comply. So I applaud Tennessee for doing that. The other one that can get really screwy is services. Services are generally not taxed, but some states do tax services more broadly than others. Hawaii, New Mexico, North Dakota, Texas will tax some services. And that can get really weird. The example of, if a state's going to tax architectural services, okay, you've got a customer in Texas that is building a building in New York. They contract with an architect in Florida, but the designs are done in Georgia. And so, you've got all these things going on. Well, how in the world do I determine where, my sales are sourced for complying with these Wayfair thresholds? That's always been an issue. Where's the incidence of tax for services? That's not going away. I think that's why a lot of states have shied away from taxing services, because it is so squishy, to use a technical term. But I think we'll probably see more states try to assert tax over services. So what should you do? You're listening to this, and so what should you do on your end? My advice is to really get a handle on your Nexus sales tax footprint. It's not just the old physical presence days. You've got to be aware of where you are selling goods, where you're licensing your software. In those states, is that item subject to tax? And if it is subject to tax, have I met the threshold? How do I apply these thresholds? As I mentioned, there's 500,000 in some states, 250,000. 100,000 in others. I do think the good news is that a lot of states are kind of forming around the 100,000 threshold. And I think as states viewed that as, okay, that's what got a passing grade. In the Wayfair case, Tennessee just went to that. We just dropped our threshold from 500,000 to 100,000. So that's what you really need to be focused on, I think, because this stuff is not going away. Just the things you think about. every state has enacted these Nexus provisions. Honestly, I've not seen a lot of states be aggressive on that. I don't know if we're in something of a grace period with these Wayfair remote seller provisions. I think a lot of the states were frankly surprised that they got that. So maybe they've just been slow to react to that. But if this is a grace period, I don't think that's going to last forever. What do I do? Get your arms around these the specific facts and document what you're doing, where you're making sales, who you're selling to. I mean, one thing that not to lose track of, if you are selling tangible personal property for resale, your customer is going to take that property and sell it to someone else. Well, then everything you sell is going to be not subject to tax under the sale for resale exemption. But still, you need to understand the states that you're selling into, and how does that go into the measurement of the 100,000? Tennessee, for instance, has guidance when you're trying to assess our 500,000, now 100,000. You look at your sales, you include exempt sales, say to not-for-profit entities, but you exclude sales for resale. So if all you're doing is selling for resale, then you may not meet that 100. You wouldn't meet the 100,000 in Tennessee, and that may be the case in other states. I think if states haven't gotten to it yet, they're going to come around to it. And I can tell you who is thinking about this. We see this come up a lot in deals and acquisitions. And the classic case is an acquirer comes in, they're going to buy maybe a software provider. And they're going to look and they're going to say, oh, geez, it seems like you've been licensing goods in 16, 20 different states. It looks to us like you've exceeded these thresholds. Gosh, you've got some unpaid sales tax liabilities you're in arrear on. This is going to be a real pain for us. We're going to have to do VDAs. We're going to have a lot of work. So you know what? We need a concession on the purchase price. And so if the states have been slow to react, this is a big issue in deals now. And it can be used as a sword in my example, or it can be used as a shield if you have your arms around this and you really have a good handle on it. So whatever you do, when you do this, document it. You may decide that, look, we don't have to file. We've gone through and we did an analysis. We figured out we're below the thresholds in these states. We're doing sales for resale. We're selling to exempt entities, and we've got our exemption certificates in good order. So again, just as I say at the bottom there, stay cognizant and vigilant, because this is not going to go away. Maybe I can leave you with some good news. What's the good news that comes out of all of this? Well, maybe we're moving towards some level of certainty. We're getting away from kind of these tortured physical presence, indirect physical presence concepts. The bright line thresholds, again, certainty, a safe harbor. My example is, okay, if you exceed these and you have Nexus, maybe when you don't exceed these that you don't have Nexus. You're selling, $99,000 worth of goods in a $100,000 state, or 199 separate transactions. So maybe there is some certainty there with these bright lines, as they call it. Competitive disadvantage. For years, I would have companies tell me that, okay, yeah, we get it. We think we may have physical presence in a state, but you know what? If we register and start collecting tax, my competitor is not. That automatically puts me at a disadvantage because I'm charging sales tax. My competitor is not. So I'm going to take my chances. If everybody is collecting and remitting, maybe that does put everyone on an equal footing. More certainty forthcoming as the shock of Wayfair weighs off, states settle on a common bright line standard. I think it may be this 100,000. I did look at this. It looks like out of all the jurisdictions that have imposed a remote seller threshold, 37 of those jurisdictions have seized on 100,000. Again, I think that comes out of Wayfair. Some have gone with the 200,000 transactions. Others have not. Tennessee did not pick up the 200 transaction threshold. And I think that's good. I mean, that could really pick up a lot of small sellers who really don't have the wherewithal or the ability to remit in states. And from the state's perspective, do you really want a bunch of returns, showing 5 cents of sales tax liability? Probably not. And then the last point, will Congress step in and speak under this topic? If business is saying, gosh, we've got all these different thresholds we've got to pay attention to, does that incent Congress to step in, maybe put in some universal guideline that would apply to all states? Congress certainly could do that. I guess I'm not holding my breath for that to happen. So hopefully I've left you with some bad news, but maybe some good news too. And again, it's here. We have to deal with it.